Hi, everyone, and welcome to Truth Defense Live. We are in London covering the appeal hearing of WikiLeaks founder Julian Assange. Today was the second and final day of this appeal hearing, and the case is now left to two High Court judges to determine if Mr. Assange has one more opportunity to appeal before the UK High Courts or if he enters the extradition process. Now, tonight's live stream is part 2 of a 3-part series. If you missed our first episode, which streamed last night, you can check it out in the description of this video. This panel, in this series, we are joined by an esteemed panel of experts, including journalists, activists, lawyers, policy experts, to discuss the latest developments with this case. This evening, we are joined by Matt Kennard, journalist with Declassified UK, Richard Medhurst, independent journalist, Dustin Hoffman, policy advisor for German MEP to the European Parliament, and Professor Richard Werner, an economist, and I'm your host, Taylor Hudak. Before we do open it up for a general discussion about this case, I'll hand it over to Richard Medhurst to discuss just briefly what took place in court today. Again, this was the final day of the court hearing, so if you could just let the viewers know some of the main points and takeaways.
Well, today was, the Americans, their lawyers got a chance to present their side of the story and what they thought about the appeal points presented by Assange's team. And it was basically, the CIA sending a lawyer. That's what it was. We had the CIA in the courtroom, trying to hammer down this point, ram this down our throats that what Julian did is supposedly illegal, and he released so many documents, and these are just moot points. I mean, it's a repetition of what we heard already back in 2020 and 2021. It's nice, of course, to get back to the crux of the issue instead of focusing on other things. But nevertheless, these are absurd arguments. I actually wonder how she could just stand there for hours talking about this. So she tried to make the point that the WikiLeaks publications harmed people. Of course, there's no proof of this. The Americans had a task force that was run by the army. They couldn't find a single human being that was actually harmed by any of the publications. And then, of course, Assange's lawyers responded to that by saying, you have to, were this to go to the European Court of Human Rights, you have to carry out a balancing act where you say, is it proportionate? What was in the documents? What was being disclosed? Well, torture, war crimes, drone killings, assassination. So, yeah, that is much more important than the supposed risk that was, incurred to these informants. And so, this is a very, very important issue because we always have to present the fact that what was in the documents is more important than whatever the United States claims happened and did not even happen. And then, of course, they talked about the extradition treaty versus act. This is, again, a very, devilish trick that they planned already 20 years ago when they first drafted this legislation and signed it, of course, with the United States, because they made sure there's a loophole. The treaty is the bilateral agreement between the United States and the United Kingdom, and then when it comes to its implementation in English law, they made sure to leave out the part that says you can't extradite someone for a political offense, which opens the door to what we're seeing right now. So, these were the main points of contention, and I'm sure we'll get back to a couple of others.
Absolutely. Yeah. And just to make it clear for the listeners, on the first day, yesterday, the defense had the opportunity to present its arguments. And then today, it was the Crown Prosecution Service, which is representing the U.S. government. And there were 3 lawyers representing the U.S. government through the CPS. One of them was Claire Dobbin. I think she spoke probably the most today. And then the defense had another opportunity to rebut the arguments of the prosecution. So that's just for your information to understand the basic structure here. But now I'll hand it over to you, Dustin. What is your general impression of what you witnessed today and yesterday?
Yeah, I had a similar impression because I had the opportunity to follow the proceedings already in 2020. And today it was like listening to the same arguments again, like also yesterday, from both sides, but on speed or steroids. It's like it was really short, and also they always mention it. I have to keep it short. We have to be fast, and I think that made it quite difficult for both sides to present their arguments in a proper way, which sometimes, especially today, for the US side, led to some very unstructured arguments where I had difficulties following their arguments. not only because of the audio issues which have been plaguing the court, but also because of the arguments. And still, especially like the Treaty Act stuff was quite technical, still quite interesting to see because, for example, I took the opportunity to look up the Max Planck Encyclopedia for Public International Law article on extradition, which says that basically every single democratic country which has extradition treaties has excludes extraditions for political offenses.
Of course, yeah.
And the funny thing is then that they there discuss that usually the issue is what a political offense is. So people discuss that and not the question if it's barred or not. And there, because what they also say, it wasn't even a political offense. And if you look up the encyclopedia, what it says, like there are like some clear political offenses like espionage. And she today even said like, oh, well, that's not even a political offense. And a political offense usually is an offense which is directed only at the state. So if you are, of course, like committing espionage because you want to hurt your neighbor, then it's maybe not a political offense, but then it's not espionage. So it was quite weird, some weird arguments, but it was always the case. And the big question is why back then the district judge disregarded the good arguments. And we can just hope this time that the two judges now will act differently.
Absolutely. Now, Matt, I know that you were also present in the courtroom. You've also been covering this case quite a bit. What was your general impression of today?
I mean, I'm more hopeful coming out of this than I have been in the other hearings, and I think a couple of people have said that to me as well. Just because the judges seemed more engaged. It could always be a PR strategy from their point of view in that it's the end of the road and they don't want to appear to be as dismissive as the previous ones. But I just felt they were engaging with the material in a way that I haven't seen before. The judges previously were not shy to show open disdain towards Assange, which you shouldn't do. It's really not a form to do that. And I mean, the judge, when Assange first came out of the embassy and was going to go to but on his way to Belmarsh, Judge Snow actually called him a narcissist in the courtroom for no reason, and that kind of carried on that disdain. But today I didn't see that, which was hopeful because as anyone who's listening to that from a neutral, independent point of view, listening to the arguments, you're sort of like, how can this go ahead? This is clearly a political prosecution. It's clearly a violation of multiple articles in the European Convention on Human Rights, which they went through, like foreseeability. Freedom of speech, freedom of receiving and giving information. So, and it did all get aired. And actually, I felt like the US lawyer today, Claire Dobbins, she was struggling at different points. There was one particular point. There was one point she struggled, but there was no sound, which was a theme. But there was one point she struggled, which I heard, which was when she was talking about the cable releases and the fact that it risked harm to the human sources, and then the judge sort of asked for clarification. She said, "But wait a sec, didn't another website publish all that beforehand? Cryptome, right? This
I'm
website."
so glad they asked that question.
Yeah, and then she
Thank
sort
God.
of said she was shocked that she'd been asked because it was usually hands off for previous judges, and then she said her argument was. It wasn't that. It was because he obtained the information. That the problem is, it wasn't that he released it first, and then you're sort of like, well, no, that's not the problem. No, you've just been saying that he put these people at risk, but the information was already out there. So, I mean, again, so I felt it went well, but again, we're dealing with the British justice system, which is an oxymoron. There is no British justice. From the start, this has been it's been a kangaroo court. The fact is, even in Belmarsh maximum security prison as well, the penal system's been captured by the state in this case as well. He's in a maximum security prison. He's never been convicted of any crime apart from bail violation, which is a minor infraction in this country. Yeah. And it was a spent conviction before 2 years. He's now been in there nearly 5 years on remand. Really? And this is in a prison that they call Britain's Guantanamo. It's full of rapists, paedophiles, and
Al-Qaeda
and terrorists.
And they've been given better treatment than he has.
Yes, and
from
actually,
prison.
One of the early stories a couple of years ago we did at Declassified is I sent a Freedom of Information Act request to the Ministry of Justice to say, can I get a list of all the offences of people in Belmarsh, and there were, I think, 770 inmates, and only 2 had been were in there for bail violations. This was when he was still in for that. which is amazing. And like it was like 40% was violent offences and all the sorts of worst crimes you could imagine. So clearly the state is acting, and the political system is acting on a legal system, which is an outrage in itself. But really, Assange exposed the US empire, but I think he also has exposed the media, secondly, but he's also exposed British justice as a joke. So in this case, particularly today, we've done a bit of work at Declassified about the judges in the courtroom today, Sharp and Johnson, was it? Johnson. And Johnson has previously acted for MI6, the Foreign Intelligence Agency of the UK, and Sharp's deeply embedded in sort of the Tory establishment within the UK. Her father was a life peer. Her brother was the chair of the BBC until...
Isn't he the one that got fired or he had to resign?
Yes, exactly. So he was chair until last year when he had to resign. So in that context, I'm not hopeful. Although I actually think... Someone asked me, are you hopeful? And I was like, well, I'm hopeful that they might win this decision, but I think that might be part of the US strategy anyway. That they want to... The punishment is the process. And at the moment, you've got the prospect of a new Trump administration soon. Do they want Assange there in the next under Biden in the next 6 months, or would it be better for them to for it to go back to the appeal, keep him locked up and in a hole in London for another couple of years, which they could do? Because the other thing is, even if he loses this ruling, he can then apply to the European Court on Human Rights. Of human rights, and then that can take and they can issue what's called a Rule 39 straight away, which would stay the extradition, wouldn't stop it, but then gives the European Court time to look at the case. And I was told this week for a story I was doing, I interviewed Assange's lawyer in Europe, and he told me that it takes a minimum of 18 months for the European Court to make a decision. And in the case of Baber Ahmed, who was a UK citizen that was extradited to the US in 2012. I spoke to him the other day. His ECHR application took 5 years to process. So it could go on and on and on. So it could be like if it goes back to the appeal court, we could be talking like 7-8 more years if the ECHR. So I personally think that's what the US want. They want him because it's going to be
written that. So
and it's going to be a circus if he goes to the US, isn't it? Like. So they want him dead here, preferably, in my opinion.
Right. Now, to go back to your point about the line of reasoning of the prosecutor, Claire Dobbin, the way I took or understood her statements with regard to the release of these particular documents, where she was stating that WikiLeaks did something unprecedented by publishing this information. Then she was questioned by one of the judges. Well, by the way, in fact, these other organizations published first, and they did not redact the names. She seemed flustered by that. But then she made an argument stating that, well, he obtained those documents, which made it possible for these others to obtain the documents. And that doesn't make much sense, because that told me that she thinks that he is therefore responsible for, say, the irresponsibility of others or for other people's actions. That is pretty absurd.
Yeah.
Could I just add one thing to that?
Sure.
That it's not a crime to publish the name of a human source that you get told anyway. Anyway, so in fact, when I was listening to her arguments today, I was sort of like, this is a nail in the coffin for any kind of national security reporting at all. Because if you signed an Official Secrets Act in the UK or its equivalent in the US or wherever it is, okay, yes, it is a crime.
Yeah, that's different.
But if you're a journalist and you've received that information, you are allowed to publish it, even despite all these arguments that the US is making. So it really would be, if they extradite him on the merits of those US arguments, it's a nail in the coffin for investigative journalism, also freedom itself, because we're essentially giving the state the right to tell us what it is in our interest to know as journalists, as citizens, and that's fascism.
Can I just add the thing with crypto? It's so funny because the owner of the website, he submitted a written testimony to the court, and he said, I published them first, and nothing happened to me. The US government never contacted me. They don't want to prosecute me.
Yeah.
It really illustrated and underscored the absurdity of all this. It was a short and sweet thing, and this is already back in 2020. During the time at the Old Bailey, but it's been entered into the court and it's on the record. And number one, I'm shocked the judges don't know about this. Number two, I'm shocked that this is happening. And this shows you that it's selective. That they want Assange. They don't care
Yes.
about the law, and again, it's not even a crime. But on top of it, it adds another layer, and it shows you it's selective.
Yes, perhaps relevant to that is the practice in this country to use so-called D-notices, and then expecting journalists to essentially obey. And so these D-notices are government issued notices, usually by the secret services, which themselves are secret. And so you're not meant to ever mention that, oh, we had a D-notice on that. That's internal news when your editor tells the colleagues, well, we can't talk about this, we've got a D-notice. The D-notice itself is supposed to be secret, untouchable, and you're supposed to be silent. And it's really, I think, about enforcing that old system, which by definition is not transparent, is not democratic, does not use principles of a free and democratic society. And of course, it's been challenged by the new technologies and the new forms of journalism, where you don't just have the big media companies, where there's collusion between big business, big media companies and government, as we know, mainstream media, but we have independent journalism. And it's this sort of tug of war that's been going on in the last decade or two, increasingly, of course. And I think they haven't come up with a proper sort of solution how the system is going to handle this. And I think Julian Assange case is a way of trying to maintain the old order. And of course he gets punished because WikiLeaks by definition was completely just ignoring all these establishment rules, which were they're not democratic rules anyway, and very hard to defend. And so I think it's good that with this case at least awareness is increasing, and all the good work of independent journalists is spreading the word, and people are becoming much more aware of this. And we've had great demonstrations also today after the court closed for business. The public is increasingly aware, and in some countries in Europe, people are also demonstrating. In Germany, for example, for Julian Assange, and people just don't want journalists to be put in jail for doing their job. I mean, it seems crazy, and that's really what it's about, I think.
Can I just go back on this, because we actually got a D notice.
You did.
Well, we didn't get it. It's like you said. It's a very sort of loosely defined system on purpose. It's like a gentleman's agreement, and no one ever says no. So they sent us the D notice committee sent us an email saying, we've done this investigation on Paul Biya, who's the oldest dictator in Africa. He's the Cameroonian dictator, and my colleague Phil Miller had done a story about UK support for him and drawing up contingency plans, and had the name of a special forces soldier who had drawn up or been involved in drawing up a contingency plan to keep him in power. We published that. They approached us and said, we are just approaching you in a sort of nice way to say, can you censor your article? And Mark Curtis, the editor, was it's a really hilarious email chain, because he's sort of trying to say, is this a D notice? And they're like, no, it's not a D notice. And they're like, well, what is it? And it's like, it's just some advice. And I was like, so is it official?
It's like the mafia talking.
Yeah,
to you,
but they're so used to no one pushing back, so they didn't even know. Like, honestly, you got to read it. And then eventually we refused, and we wrote an article about why we were refusing to comply with the D notice committee. But as you say, this happens all the time, and no one ever talks about it. It happened recently. Just to finish with this, it happened recently with Gaza, because there was a story in the Sun newspaper, which is one of the most disgusting newspapers in the world. But they got this story that the SAS had deployed to the British base on Cyprus for Gaza operations for hostage rescue, apparently. Anyway, the following day, a D notice was issued to every single editor in the UK saying, do not publish any information about UK Special Forces involvement in Gaza. That was published. No one publicised it. It was eventually publicised by one newspaper that received it, called The Socialist Worker, which is like this tiny leftist weekly, and they publicised it. But it's never been talked about by anyone else, and there's never been one more bit of information about the SAS involvement in Gaza since that day.
Scandalous. How is that not relevant? Or big news,
and also any journalist because it's a voluntary system. They say it's a voluntary system. We have no. But that any journalist that is complying with that D notice is complicit in the genocide in Gaza, in my opinion, because you're withholding information and you're not even at risk of prison like Assange. But it does go to how the system works, which is a gentleman's agreement, and they're all from the same Oxbridge universities, all from the same private schools. They all go to the same private members club, so they don't need the official rules. This is why Assange kind of pushed the boundaries and took journalism seriously, and then they had to say, well, actually, shit, we don't have an infrastructure to stop this because no one's ever tried it before. And now we're seeing all the ridiculous arguments that they have to make to try and justify this prosecution, which is ridiculous.
Now, I do want to take a moment here to introduce another guest who is, in fact, the editor-in-chief of Truth Defense, the platform that we are streaming on. Welcome, Mohammed Almazi. We're very happy to have you able to join us again this evening. So I just went around asking the others for their general impressions about this case, what took place over the past few days. So if you want to weigh in on your general thoughts. And then I do also want to get into the courtroom conditions briefly, because a few of us have had some difficulties, and it speaks to some of the struggles we had as journalists to cover this. Although it's not a big point, it's still important for people to understand some of the hoops we had to jump through. But first, I'll hand it over to you for your general impressions.
Thanks, Taylor. Actually, I just finished reading Kevin Costello's article on the way over here that he very quickly wrote up and published today about, conditions the court plagued with problems for media access, in which he quoted like a number of us in there. So it was interesting to see somebody who's taking it seriously, not least of which because he was not permitted to have a remote access link, despite the fact that he'd covered it previously. He'd both physically come to the UK to cover part of the extradition hearings, and he's also covered them via video link, and then for some reason he just couldn't do this one. So I was covering the hearings for the dissenter. I'd have to agree that it's one of those things which I agree with Matt, but there's also who is it? I think Joe Laurie yesterday said this as well, or was it Craig Murray, that on the one hand I've had this bit of optimism. On the other hand, I don't want to feel optimistic because I know that disappointment is a function of expectation, and the greater my optimism or expectation, the harder the pain when the decision comes out which is not what I expected. So the judges seemed engaged. Johnson, in particular, the one who had part of his career was representing the national security state. Maybe it's because of the articles that you guys wrote about that he thought, okay, I've got to really appear to be really interested in this. Because the previous the original judge who oversaw Julian's extradition case, stepped down after Declassified UK published an article about her family's husband and son's national security links and anti-WikiLeaks links. I'm not saying that there's a causal link, but there's definitely a correlation. Article came out, and then she stepped down. And then somebody who I'm not necessarily certain was better than replaced her. So it's you have to be careful what you wish for. So it was interesting today. The one thing I'll say about this before we get on to other people to speak, I suppose I was sort of surprised at the severity with which they pushed the Julian Assange and WikiLeaks aren't legitimate journalists or journalistic organizations. It's not that they hadn't said that before, but that was sort of, from my recollection from like 2 years ago, they're sort of in the background. It was there. They challenged it. It was an important point when they said their argument before seemed to be they have crossed the line. He has crossed the line from legitimate journalism when he pressed Chelsea Manning to give him information.
Like he's
Curious
a recruiter
Eyes.
of hackers or something.
Whereas now they're not legitimate. They were never legitimate. Even before they even spoke to Chelsea Manning, he was engaged in conspiracies to solicit confidential information. That's also known as journalism, right? Conspiracies to solicit. So if I go to somebody and I say, hi, do you have any information that might expose, corruption or malfeasance or wrongdoing? That's a conspiracy for me to solicit classified, stealing. That's it. They started using the term stealing a lot this time as well. Not leaking, which is what they were saying before. So Chelsea Manning is not a whistleblower. She stole classified documents and gave it to her co-conspirator, criminal, non-journalist Julian Assange. And they're hammering this for like a couple of hours. So I was kind of surprised with that. Not the fact that they're defending their position, but just the severity with which they decided to take that position. Although, as Mark Summers did, I think, a very good job reiterating, which is a point they made yesterday as well. The unredacted cables that they made a big deal about only represent 3 out of the 18 charges. So the position was, well, what's your excuse? If you're saying this is crucial to your case, then what are all these other charges about that have nothing to do with unredacted cables? Okay, are you going to dismiss those? I was like, well, no, obviously not. So it's not really about unredacted cables. And like Matt mentioned the point about going to the heart of national security journalism, not only in the United States is it not a crime, and they've attempted to pass laws and failed in Congress, is it not a crime to name the identity of a source or an asset? But under the Espionage Act, it doesn't matter. It doesn't matter if what your motives are. It doesn't matter what the documents say. It doesn't matter if the prosecution, admit, okay, no one was harmed. These are strict liability offenses. So all they're going to say is this national defense information? If the judge agrees, the next question is, did you possess it without authorization? Yes? Guilty, 10 years. Next charge, same thing. Guilty, 10 years. So when Claire Dobbin repeated the mistake, I'll call it, of Judge Vanessa Bracer when she said, these are issues that Julian can raise at trial in the States, that's completely false, because he can't raise them at trial, because if he attempts to raise any issue at trial that doesn't have to do with the technical aspects of possessing the documents, the prosecution will stand up, say, objection, that's immaterial, the statute doesn't matter, it's silent on the matter of harm or damage or motivation, and the judge will say sustained. And that's exactly what judges have done in previous cases in the Eastern District of Virginia under the Espionage Act.
Exactly, and it seems that the lower court judge, Vanessa Bracer, did often state in her judgment that she was going to leave it to the U.S. courts to make determinations on several of these matters. Do you have any insight on this? What do you make of that? Do you think it was perhaps out of just hesitancy, out of fear, or just not wanting to really bring herself into that controversy, despite the fact that it is, of course, her duty to do so as a judge, to make rulings on these matters and to issue opinions?
Well, in fact, she can't, because she doesn't have the necessary information to make such a ruling, because they're secret. It's like, because she just can't. I think, like, in many aspects, what we have to keep in mind is that this was a pretty big case for such a court, for a district judge as well. It's not about her qualification, but usually those extradition cases are just rubber stamped. Someone committed some crime, and then you just send them over. It's fine. This is how it usually works. But this is such a huge case, and I have to admit that I don't want to be a judge like doing this, like such a huge case. And at some points, I felt that she was a bit overwhelmed, and then it is an easy way to push it away. But also many, and the US barristers mentioned many times that this is something we can't talk about. This is something we don't know. We don't know about evidence. This doesn't matter, because it will be decided according for her. Of course, it's a very comfortable thing to say. Well, we can't talk about it here. Would be more difficult to address these issues. Also, but this is like in a reverse mode. I think this is something Julian's defense did yesterday, is that they talked a lot about the European Court of Human Rights, where they, what I felt, wanted to give the court the impression that if you fail here, you're gonna fail in Strasbourg, and you're gonna look bad.
Absolutely.
And whatever you think about the judicial system, I think that the judges do have some like judicial honor, and they don't like losing. And I don't think they want to get embarrassed in Strasbourg. And I think yesterday Julian's defense was appealing to that like judicial honor to someone. This has nothing to do with like honor because of journalism or Julian, but only because of themselves. And I think this is something that could work. I don't think they want to knowingly lose in Strasbourg. So they, if they want to continue, if they want to extradite Julian, they have to make a better case. Because right now, I think it would not sustain in Strasbourg.
Very interesting. I mean, from my perspective, when I listened to the judge's questions, it very much seemed as if they were almost poking holes in the prosecution's case. They were obviously not aggressive or combative, but they were challenging them, and it was good to see that, as you had said and several others yesterday, really for the first time, when you look back at at the broader scope of these extradition proceedings. Now, I do want to touch on just briefly here the courtroom conditions. We did talk earlier before we started filming that there was some difficulties with being able to hear the judges and the lawyers present their case, and there was also difficulty with seating. And then, as Mohammed was saying, many of our fellow journalists who are not physically within the jurisdiction of England and Wales were prevented from covering this case remotely. And this is a new policy in this case. Previously, people were able to be anywhere in the world and have access and cover the case. People who have been covering it for many, many years were prevented from doing so. And of course, we can only, make guesses about why that is, and it's not really helpful to necessarily go into the realm of speculation. But any thoughts that you have about your experience? I know that you are supportive of Julian Assange and free speech and free press. What was your experience like in the courtroom as a member of the public?
Yeah, well, exactly. Starting with the courtroom, I mean, attending yesterday as a member of the public, I was in the sort of overflow courtroom, and the acoustics for the first, I don't know, almost hour or something, at least 45 minutes, was so bad. People were shouting, "We can't hear anything, we can't hear anything." The staff, the clerks, pity them. They didn't know what to do. They're clearly not IT experts or, experts in getting good acoustics and microphones working. It was pretty much a disaster. It got a bit better, don't know exactly what they did, but still, it's very, if you're a member of the public, an interested member of the public who wants to make use of the right to witness an important public hearing such as this, which has a high public interest, content, I think. Well, maybe you didn't hear very much at all, So definitely the sort of logistics was very disappointing. But there is this other point I want to come back to, Mohammed's point on this attempt to legitimize WikiLeaks and well, sort of also independent journalism, perhaps even citizen journalism. And because we've seen this particularly in the last 4 years, this accelerating campaign against alternative opinions. To me, it's almost as if the state, big state and big business, they just want to control the information. It's really about information control. And they seem to have come up with this idea that, well, we'll just define what journalism is. And, well, sorry, guys, what you're doing and what Julian Assange is doing, well, that's just not defined as journalism. I mean, anyone could claim to be a journalist, but it just doesn't pass our definition. It's essentially what they're trying to argue. If you work for a legitimate major news company and so on, part of the cartel, that is journalism. And if you look at the recent bills and European, Digital Media Act and all this stuff, Freedom of Media Act and all these euphemistically called pieces of legislation, they essentially distinguish, if you are an ordinary person, then, well, you can't do this, that, and the other, and you can be punished for spreading misinformation. But if you're a big business, I think this was the recent legislation, if you are a major mainstream media company, then, or you can make mistakes and maybe sometimes it's not accurate, that's not misinformation and you won't be punished for it. And that is pretty scary what's happening. And I think, of course, in many ways, Julian Assange was still under the old approach as we discussed, and so they have to use all the methods there. But it's so relevant for everyone because they are working on easier ways to shut down dissent and essentially suppress the spreading of important public interest information by simply having laws that just says, no, what you guys are doing, it's just not allowed because we define it as it's not journalism.
You do it like that so that you don't have to give them the Assange treatment, right? So institutionally, structurally, funding-wise, in terms of algorithmic changes on social media, so eventually it just becomes impossible for you to do any kind of meaningful alternative journalism. They'd much rather that than having to use stormtrooper tactics. The heavy-handed approach with Assange, I don't think is there. I mean, in Egypt and Turkey, yeah, they have no problem doing that with thousands and thousands of people in prison there. Journalists in particular, or media workers. But countries like Britain and the United States, they see how bad it looks. And I think they're like, okay, we've delivered the message. How do we prevent future WikiLeaks's from emerging? And not even at the level of WikiLeaks, even something like 1% of what WikiLeaks does.
Yeah, I mean, just to the the sound issues. I mean, this is England. I mean, we invented going back to the telephone and stereo itself. It's scandalous that this is the Royal Court of Justice, and you go in and the sound doesn't work, and you go to the Old Bailey and the sound doesn't work. This is it's not just because it's England, but it's really embarrassing for any country that wants to say it has open justice and it's a technological wonder. It's really shameful. It's so bad, and it's not complicated. You just got to stick a microphone in someone's face. They could. I will happily buy the microphone for the bloody court if it comes to that, and clip them on. It's really not that complex. They just don't want to. So I think it's a mix of conspiracy and incompetence. I don't know what it is, what the ratio of each part of that is, but that is the cocktail that we're talking about. And when it comes to again, I didn't want to tweet this earlier, but I'll just say it here because it sounds better. Claire Dolan, I think she maybe speaks too quietly because she's ashamed of what she's doing. Maybe it's a conscience that's talking. So maybe that's something to do with it. But this is really scandalous. I mean, forget like the content of the case for a second. Just the technological hurdles that they placed, and also the fact that people like Kevin and Mary and they haven't been able to cover this case. I mean, it's funny in a way because Mary's in Australia, so I mean that's where Assange comes from, but she can't see what's happening to her compatriot, her fellow citizen. And then when it comes to Kevin, he's in the United States where Assange is headed, hopefully not, and he's not allowed to know what will become of him. I think that's just it's really ironic. And of course, this rant, if you want to call it that they went to. They went on about today regarding WikiLeaks. I mean, it's so farcical that we have to explain that, torturing people is worse than harming informants. I don't give a crap about the informants. You know why? Because they torture people. They kidnap people from the streets of Europe and take them to black sites and then sexually assault them. You can go read the case files. That's what happened. It's because of Julian Assange that we know these things, and victims of the CIA could prove that in court. Just snatched off the streets in the EU, which is supposed to be, these are supposed to be safe democratic countries. And you have to wait for, Julian Assange to publish the documents and then go to prison for you to get some justice from the what the CIA did to you. And then your government will protect the CIA agents over you. I mean, this is so scandalous for European governments as well. We have to underscore this. It's not just England, It's also Spain, Germany, Italy, all of them. The US have their clause in them firmly, and that's not an excuse to say like it's just the Americans. No, the people in those countries are also complicit.
Which we know because of WikiLeaks, by the way.
That's the irony.
WikiLeaks cables also showed that the US government was interfering in the prosecution, the attempted prosecution, because there were investigations being opened up against CIA and others. And the U.S. government was actively intervening to stop those cases from proceeding. And we know that because of WikiLeaks. So we even know that WikiLeaks itself was a target of the National Security State in 2008 because of a leak to WikiLeaks that said, that it should be considered a hostile entity. And that was in 2008. This is 2 years before Chelsea Manning. So, and it was a much smaller organization, and most people had never heard of it. Actually, Krypton had a far wider reach, was far better known among most journalists than WikiLeaks was at the time. I mean, even at the time of publication of the cables, which is a point that was made actually by a computer expert.
It's wild to think about that.
Yeah,
right?
I know, because I mean, who thinks of Krypton now, right? But at the time of the publications, Krypton was much more well known, and more importantly, the Google algorithms were more likely to link you to Krypton at the time than it was to WikiLeaks at the time. One quick point on the media access. So, I applied early. I've covered every single hearing since April 2019. I got in yesterday, got into the press section with a table, great. I came in today even earlier to make sure I got in. Wait in the queue. When I go to get there, No. In fact, I do get in. I sit down, and then a clerk comes to me and said, all of the press seating, all of it inside, are reserved for Associated Press. And by that, they don't mean the AP. They mean news outlets that have been designated Associated Press status, which is BBC, The Guardian, Sky, various establishment outlets. And so they're like, oh, so where am I supposed to go? They're like, okay, you go up to the public gallery up there. And I'm like, I have my computer. I need to be actively typing. I also have a physical disability. I cannot write. That's the public gallery. There's nowhere to put your laptop on there. It's just like, well, I don't know what to say. It's like, I'm a member of the press. This is the press section. You're saying I need to go up to the public gallery where I can't do press work because some journalist who is not here and has not queued up just because of his association with the BBC or what have you, or is attached to an establishment outlet.
It's probably a spoof.
And you should have seen their face while they're standing by the position. You could tell that, like, since I'm raising it, I'm like, this is outrageous. I've covered every single hearing over 4 years. None of these people know the first fucking thing about this case. I see people who I know, I don't have a problem with them personally, but I have never seen them in any of the hearings, the dozens and dozens of hearings, because their news outlet hasn't been sending them to cover it. I've been paying my own way and been paid by, like, indie outlets, like, hemorrhaging money so that I could cover every hearing. In the end, I had to go downstairs at the bottom where the press section was using the live video link because I couldn't even get to
Dude, after they threw you out, me and Chris had just sat down, they threw us out, and we had to go, like, in the same room, like, just, why? There's no one there.
Why took you guys down?
Like, I have to put the laptop on my knees instead of a table because there's an invisible journalist, a ghost, like, on the...
We all have press cards, we all did it on time, we all did it early, we've been here before covering it, and some people, I was just, it's out, what the fuck is the point of having a queue? If you're going to say there's some press, but not all press are equal, but some are more equal than others. It's my point that you were making.
I just want to bring up one point which I found so unusual but very interesting. I was actually outside the courtroom waiting to get in. It was first thing in the morning, and one of the court staff members looked at my ticket and said, okay, you have to go upstairs. I said, well, I was, in the lower level yesterday. I'm press. I asked to be here. I've been approved. And they told me that the judges decided that the press should go on the balcony on the second level and the public is to go on the first level. And that was because they were worried that the members of the public could be angry protesters. And if they're in the top, the second level, that they could potentially throw things at those involved with this court case, say the judges, or the attorneys. Which is such a ridiculous
Wait,
thing
so they
to
wanted
suggest.
them closer to the judges?
Yes, exactly. It doesn't make any sense. But that's what they told me. I was fortunate enough. I was able to be on the first level. But they did also ask for my ticket, my card, and wanted to... They told me basically if someone with the AP comes in, then you have to move. But anyways, I don't want to harp on this point too much because we should... focus on the substance of the case, but I thought it was important for the listeners.
They want to hide what's going on.
I think it goes to an important point, which is like a central tenet of the justice system is open justice. That you have to be able to access information about the judges, if it's a jury, about the jurors, about see the case, get transcripts. This case has just been... There's been no open justice. They made it as difficult as possible to access him in Belmarsh, even for civil society. Rebecca Vincent, head of campaigns at RSF, had an appointment to see him at Belmarsh and was turned away at the door. And and this is stuff that you see in places like Turkey or so. In fact, I was sat next to Can Dündar today. I don't know if you guys know him. He was the editor of a major newspaper in Turkey, but he was persecuted for journalism, much like Assange is. And he now lives in exile in Germany. And I said to him, how's this compared to what you put up with Turkey? He said, Turkey's better. But in terms of open... And Rebecca Vincent said the same thing.
Allied countries.
Yeah.
You mentioned Egypt and Turkey.
And you're just sort of thinking, it's like you said, there's probably not much point speculating how much is incompetence to conspiracy, but there's definitely 100% no one is actively taking the seriousness of this case seriously. Like if the fact that there's going to be all these people, you'd get a bigger courtroom, you'd make sure the technology, if it's shit, which it is, make it better for this case, because it's there was one bit where it cut out. They cut out all the time. I could barely follow a lot of it. But Chip Gibbons, who's one of the American Assange analysts and supporters who'd come from America, he just turned around and just went, "This is the trial of the century." And I'm just like, "You're right. Like, this is insane." It's like we're like any self-respecting country and self-respecting justice system would make sure, when all these people are coming from around the world to see this trial of the century, the most important press freedom case maybe in history because of the extraterritorial reach it gives the US, you'd make sure they could at least access it. But they didn't. And I mean, yeah.
It's brutal. But, you know, the judge made a big deal about it after. So, I've heard that there were problems. That's not okay. So if there are issues for people who are inside court or watching via live link, please tell me that. And of course, I'm hearing this while now designated in the basement, listening via live video links. So I was like, well, at least her voice came through. Then as soon as the barristers started speaking, I couldn't hear anything they were saying.
It was mad.
And we're instructed, do not put comments into the chat of the video link thing. But it's like, I have to. So I put in comments, we can't hear. And then other people started doing it as well.
Yeah.
At some point, the judge asked one of the US barristers something, and he replied, and then he was not speaking at the microphone anymore. Like that, they have to speak directly at the microphone. Then it's fine. So we told the clerk like, we can't hear anything, and he was like, yeah, it will be fine. He will speak to the microphone again if he finished his reply. But we are not here like for selective stuff. I want to hear everything.
The maddest thing today was I left because I needed to go to the toilet from the press bit. It wasn't a press bit, but and I'm walking out towards the toilet, and the guy's like, "Oh wait, just to let you know, you might not be able to get back in when you go to the toilet." I'm like, "What do you mean? I can't go to the toilet?" And he's like, "No, because it might fill up while you're
I
gone."
haven't eaten the last 2 days. I didn't have lunch because I was afraid that.
That's mad that they've got a policy that you might lose your place as the member of the press to see the trial of the century because you need the toilet. Madness.
Honestly.
I was waiting for so long in the lunch area during lunch that I couldn't get lunch, so I had to run back to the press room because if you log out, if you don't try to log in 5 minutes before, at least 5 minutes before the thing, they won't let you into the video link. So I had to run back there, start it, and then run back out to try to grab a flapjack, something to shove into my stomach.
Listen,
What does it matter what time you join?
Yeah,
You
exactly.
wanna watch.
Why do they care? It's all automated.
I have a suspicion. I think that they are not able to mute everything. So if people join, maybe they're not muted because yesterday we had people popping up and like in the video, like with the camera on. So it's like I think what I wanted to mention about the audio quality, if the viewers can hear us clearly, then the technical team here is doing a better job than the court technical team of a nuclear country.
Yeah.
But just to broaden out the discussion again, so as you were saying, Matt, justice needs to be open, transparent. Unfortunately, there seems to be the reality of secret court trials in this country, which is another story, but it shows the attitude. But you're right, and everyone agrees justice needs to be transparent, open. And then the other point is, in a democracy, and I think we should just remind ourselves of this point, democracy only works if there is true journalism. And that means proper critical journalism, investigative journalism, alternative journalism, not the bought and paid for corporate journalism. Because who is there to hold the government, the powers that be, the establishment, the big business interests to account, if not proper journalism? And everyone understands that, and yet that's of course what's being targeted and being suppressed. So that's why it is the trial of the century, because it's about everything really.
Yeah.
I do want to touch on the U.S. Assurances that were mentioned just a few times today, just briefly, because I know that this is something that you actually wrote extensively on, because this is a point that's brought up by the prosecution often to counter the defense arguments, especially when they're talking about the treatment of Julian Assange if he is extradited to the United States. And later on during this extradition process, the United States came forward and said that he won't be subjected to SAMs. He will not have to serve his pretrial. He won't be put in pretrial detention in ADX Florence, which is not a pretrial detention center anyway. So the assurances don't make sense on face value. But there's a history of the United States breaking these assurances. You've written about this briefly. If you want to touch on that, and then I also think we should speak about Assange's health, which I do think ties into the assurances as well, because that's, after all, why the U.S. government probably felt compelled to bring these before the court.
I mean, it's scandalous that for 2 years now we've been talking about his health. I mean, obviously, I'm not saying it's not important, but the trial, the case should not center around whether he's healthy. Like, hypothetically, if he were at 100% mental and physical health, does that mean you send him to prison? Like, what kind of threshold is that? So the assurances which helped the U.S. lawyers to then overturn the decision not to extradite him and okayed the extradition were just based on what Taylor outlined. And the United States, they this is a case cited by Julian's lawyers, Mendoza, and he's dual citizen, U.S. and Spanish, and I published these documents from his case from the U.S. State Department and the DOJ and the Department of Justice, because what he got is much better than an assurance. An assurance is like it's on a napkin. It's just a meaningless piece of paper given by one foreign ministry to another. That's it. That's it. But what he got is a legally binding contract because the assurances are too weak. The United States tried to play the same game initially, and what Mendoza's lawyers did is they went to the judiciary and they said, like, can you really trust this? So the Spanish courts told the Americans, you either give us something more concrete or you're not having him. And this was actually really just about his rights under the European Convention on Human Rights, that he would be close to his family, that he goes to America, serves, he gets tried. Whatever sentence they give him, he comes back and he serves it in Spain so he can be close to his family. This is a right that everyone has under the ECHR. So, you can't put someone on a penal colony, 2,000 miles away from their family. So they were forced to sign this contract, and it was Spain that signed it, the United States that signed it through the embassy in Madrid, and Mendoza himself. And then once he gets to the United States, they start stealing, millions of dollars from him because they wanted him for marijuana, but he was actually already rich through construction. So they started taking way like 7 times more money than he had actually supposedly sold in marijuana, right? And they never caught like a single ounce of it. The point is, though, that they started robbing him blind, and then after that, they would refuse to send him back. And he asked for a copy of the document of this contract. It's like a banana republic. They gave him a copy without his signature, so he can't go to court. And then one of the judges in Spain anonymously sends it to him because he rallied so much support for his case in Spain, and he sued the Spanish executive twice in the Supreme Court and won, just because they violated his human rights and did nothing. Because we have to remember that Spain failed to tell the United States, hey, come here, what are you guys doing? Give us Mendoza. Because they're another party to the contract, and because they're controlled by the United States, they did nothing. So he won, and when he got that, he went to civil court against Obama's Attorney General, who was Eric Holder. And then when that happened, they said, okay, go back. You're giving us a headache. So you see, it shows you the power of these contracts. But again, going back to Assange is not even getting this contract. And were he to get it, we know the United States would break it anyway, and the United Kingdom would not enforce the contract. And so, whatever way you look at it, you cannot trust what the United States promised. Even if it is a legally binding contract on paper with a signature, it is garbage, it is toilet paper.
Do you remember how was the guy with the hook?
Abu Hamza.
Abu Hamza, yeah. Was very similar there, didn't they? Also, give assurances there?
Exactly, yeah. They said he'd get proper healthcare and then, put in SAMs as soon as
I remember that during the hearings they told a story that they were loosening the measures and stuff, it got better for him.
Right,
and then he wrote a letter to his son.
He said something like, give my love to my grandchild.
Yeah, tell my grandson I love him. And then they declared it unauthorized contact to a third person and said everything back to the worst. It's So I also felt like even if they in the beginning stick to the assurances, they will find a way to move away from it. So especially, I think what people have to keep in mind is the assurances only cover what happened until now. So if something else would come up, it may be misbehavior or whatever they come up with, they could always okay, this is not covered by the assurances, so go to SAMS.
Which defeats their purpose, because the whole point is he's at substantial risk of suicide if they treat him in a particular way. And they say, fine, we promise we won't help him commit suicide unless he says or does something that leads us to change our mind. So it's okay, the High Court have literally just accepted meaningless assurances which even on their own face, right, or have such a great qualification that it's basically like saying, and this was what they tried to appeal to the Supreme Court on, where they said, like, can you actually accept a qualified restriction on torture? Because you're saying that the High Court have accepted that certain conditions will lead to his death, right? That satisfies the definition of torture. And they're saying we won't torture him to death unless we change our mind and decide we want to torture him to death. The High Court said, oh yeah, well, that's good enough for us. And that it's absolutely shocking. And that is, and they refused to certify that as an appeal ground to the Supreme Court. So they couldn't even go to the Supreme Court. And I think they did that deliberately because the Supreme Court would have had to have considered that and would have been in a very embarrassing situation of either on, because Supreme Court cases are actually televised, right? So actually saying that the prohibition on torture in the UK is no longer absolute, or saying that these assurances are worthless. And they protected the Supreme Court from doing that by simply not certifying it. It was a complete bogus bullshit decision. I have absolutely no respect for the judges who made in the High Court who made that decision, because they're saying torture is fine if the US government decides they're going to do it, and we'll dress it up. So
really the underlying theme here is that the secret services, the deep state, you know, we have intelligence agencies, the so-called intelligence agencies. They're really operational, covert operational agencies that engage in, frankly, illegal activities. They are fighting for control, and so they want to clamp down on everything, and that's really what we're witnessing, isn't it? And of course, the biggest challenge to them is the public actually knowing and finding out what's happening, that we have these organizations engaging in illegal activities but being let off. And I mean, there's a great book by Fletcher Prouty called The Secret Team. It was already, he wrote this in the early 70s. He was the chief of covert operations, of special operations at the Joint Chief of Staff in the White House, all his life in the CIA. But then he became basically a whistleblower and wrote this book, which was banned for 2.5 decades. But then later with the internet, it's now out, you can get it easily, The Secret Team. And he shows that the CIA is essentially illegal. It doesn't even have the powers that it's in reality taking and exercising, usurping. And the way it works is because once you get into this, and you've got the black budgets, and there's these trillions missing, they're all off the books, then what they're doing is, and because they always use, you know, national security as the excuse, all those who in a democracy are supposed to be the sort of checks and balances on such agencies, you know, securities agencies or police or anything, they make sure it's their own people. And then nobody is allowed to name who is CIA, and it's a secret. So nobody knows that, say, the congressmen or the senators in the various committees who are supposed to watch this, well, they're all CIA. And that's how they do it. So the whole thing is actually illegal, and the public needs to know and be aware. And this is the battle that we're fighting, and that Julian has been fighting, isn't it? And of course, it's the battle against the most powerful enemy, really.
And he's exposed everything you talk about.
Yes.
Because I agree, like, I think that the left needs to engage on this issue. They call it parapolitics. How all the different secretive agencies you're talking about that have huge amounts of power. In fact, they have executive power, essentially, because if you talk, they call it the blob in Washington, right? The confluence of different, like, arms manufacturers, national security officials, blah blah blah. Like, it's becoming more and more obvious in the case of Assange, because you have Trump, who issued the initial, or the Trump administration issued the initial indictment. It's been carried on by Biden, who is apparently politically opposed to Trump, but there's a bipartisan parapolitics consensus in Washington.
Amazingly.
Yeah, and I think that's becoming more and more clear. I mean, it also goes, I have to say, for the judicial system as well, because we feel like independent judiciary is this concept we have, which is a fundamental tenet of democracy, but we don't have an independent judiciary in this country. We don't. Yeah. We clearly don't. And we don't even have the government... we don't have a media that's exposed it. That's maybe the scariest part for me, because the work we've done at Declassified has shown clearly how involved the UK government is in the persecution of a journalist. This is a journalist that is on record as the country that wants to extradite him has plotted to assassinate him. The country that wants to extradite him has spied on his privileged conversations with his lawyers. It doesn't get more serious than that stuff.
I mean, any case would just be
Yeah,
thrown out.
and
Exactly.
thrown out, and they haven't done. And in fact, in the case of Daniel Ellsberg in the 70s with the Pentagon Papers, something much less serious. They burglarized the offices of his psychiatrist to get dirt to smear in the media. That got it thrown out. Nothing in this case would get it thrown out.
Yeah.
But we found that the UK government had deployed 18 staff on the secret operation to seize him from the Ecuadorian embassy. Now, Ecuador is a friendly country. Asylum is a right enshrined in the Universal Declaration of Human Rights, and he's a journalist who was avoiding persecution, which we're now seeing the results of. How can any government justify putting 18 staff on that secret police operation?
And the Vienna Convention, you can't go into an embassy.
No, but they've never had to justify it because we did that story first time it was revealed, the amount of, and it's never been covered in the mainstream media. That's why sometimes I feel like I'm living in an Orwellian existence because truth just doesn't reach a certain level. Even like today, I felt it with at the thing. There's an amazing activist outside, and people are engaged, but it's still on quite small numbers on a sort of general level. And I'm thinking, this is the trial of the century. This is going to define freedom globally for decades, if not centuries. And it's barely touched in the mainstream media. It should be on the front page of every single mainstream newspaper. Front page. They should have been campaigning for years to get him out. Not one newspaper has launched a campaign. That's why I sort of feel like we're already living in 1984. We have this guy rotting in a prison in the centre of London for 5 years, and no one's mobilised. Civil society's been exposed, the media's been exposed. Everyone who should come to aid someone who is the victim of raw power exercised in the most crude way, they've gone absent.
Yeah.
And it's scary because if they can do it to him, they can do it to anyone.
Of course, exactly. And exactly as you say, and you mentioned the Ecuador embassy, and of course, why did Ecuador suddenly change its mind? And this is where you see how these things are connected. The International Monetary Fund suddenly gave them a loan for, I think it was $7 billion. And of course, there is the published conditionality, but then there's always the not published, the confidential conditionality. And suddenly, with billions of dollars at stake, and there's usually ways for creaming off a few percentages here and there for, intermediaries in various parties for their personal accounts. Suddenly, he was kicked out, essentially. And of course, there's other cases where basically when big decisions are made involving money, whether it's the European Union withholding 7 billion euros from Hungary, and then there's secret agreements on what should happen and which people should be getting silenced and whatever, or essentially badly treated for their work for truth and publishing important information of public interest. That's how it works. And so you've got all the major international power players involved in this, isn't it?
But the weird thing about this whole system is, it's like you were saying about this two-tiered media, where the establishment media is the official media, but they don't do proper journalism, and then all the rest of us that are actually doing proper journalism, we're not proper journalists because we're doing proper journalism. It is Orwellian. So the information is out there now, but it just doesn't reach. So the whole way propaganda is done here, I believe, having done the work we've been doing at Declassified for years now, is a propaganda by omission. They don't need to outright lie to you, although they do that sometimes. But most of the time, it's just to leave out any information you need to have a proper understanding. Yeah. In the Assange case, for example, another story. Sorry to bang on about our stories, but they're the ones I know best. There was the minister who orchestrated the arrest of Assange and the seizure from the Ecuadorian embassy in 2019, Sir Alan Duncan. He is a 40-year good friend of Chief Justice Ian Burnett, who green-lighted Assange's extradition. Right. How, if any media had reported that, if the Guardian had put that on their front page or the Times,
it's a scandalous conflict of interest.
It was scandalous. Yeah. He would have either had that ruling would have had to be revisited, or if it had happened before, he'd have had to recuse himself. But it just does. It's never been reported anywhere. So we live in this discourse and this narrative control where any information which is not conducive to state or corporate power is just erased from the public record in a sort of mass sense, in terms of mass media. I mean, you can see it in alternative media. And I think that's what the point you made is that I think that what Assange did, which none of us have ever done, is he made that kind of critical, radical journalism, which really is involved in exposing power, mainstream. He did it through The Guardian and stuff. And that was like a short burst of democracy before they slapped the lid back on.
Enough of that.
Yeah.
You had your fill.
Yeah.
Well, we do know that the case is now left to these 2 high court judges who are going to determine if Assange can appeal before the UK courts once more, or if he enters into the extradition process. Of course, there is still an opportunity to pursue through the European Court of Human Rights. Matt, I know that your colleagues at Declassified UK have investigated both of these judges. I think this is a good place to start to wrap up our discussion this evening. If you would like to provide an overview of some of the findings that may be of interest to the listeners, and then others who want to just share with the viewers your general thoughts of what comes next. But I'll start with you, Matt.
What about the judges today?
Yes,
Yeah,
the report, yes. I think it'll be interesting for people to
yeah,
hear
so
those details.
well, Sharp. It basically is a theme. We've been looking at judges all the way through this case
yes.
because it's a rich theme and no one else seems to be doing it. So we thought, why not? Sharp today, Victoria Sharp. She was appointed by Theresa May, by a Tory. Her father is a life peer. Or was a life peer, which is we have an undemocratic system in this country where the second chamber is unelected and is full of basically just aristocrats who have ruled.
You
this.
elect your senators. That's not a thing.
They've ruled the countries for since the Norman invasion. Basically, they divvied up the land and gave themselves bits nice titles, and they're still there. So that's that. And then her brother was. Chair of the BBC, another sort of establishment figure. So she's just deeply embedded in the establishment and has all the views, I imagine, that someone who is deeply embedded in the establishment does about issues around democracy and the journalism that WikiLeaks practices. And then the other judge has previously acted for MI6. Which is the Foreign Intelligence Agency of the UK, and in fact, it's not funny, is it? But I guess it is quite funny. But it's funny how blatant it is. But Jonathan Swift, the previous guy who took 10 months to write 2 pages and refused the appeal, he had also previously acted for British intelligence, and in an interview we found he'd said that British intelligence were his favourite clients because they prepared their evidence really well and stuff. So this is what Assange is up against. And they're clear, I've actually talked to people who are not involved in the case and who are not really political in any sense, and said what's the sort of threshold for conflict of interest where you have to recuse yourself? And they said it's low. If there's any hint that you have had some background that might influence your decision, you remove yourself. Yeah. And in fact, that's what happened with Lady Arbuthnot, which Mohammed mentioned earlier. We did a series of stories. I'll just give some context. This was a judge that made 2 key rulings against Assange in 2018 when he was still in the embassy. But if she'd ruled in his favour, it would have given him a chance of safe passage to Ecuador, as the UK was obligated to do, but never did. Anyway, she ruled against him. Her husband is a Tory lord and former defence minister. Affiliate on the board of various arms companies and stuff. She was actually personally funded by the Foreign Office, the British Foreign Office, in 2014. They paid for her to go on a trip with her husband. And we published about 6 or 7. We went a bit mad and published about 6 or 7 stories just detailing it all. And then she had, as Mohammed said, we don't know if it was because of those articles, but she withdrew from the case. And that's, as I say, we're small and we're alternative media. If The Guardian or anyone else was doing this stuff, he would 100% not be in Belmarsh. 100%. I interviewed Stella a couple of years ago, and she said that to me. I asked her about the mainstream media, and she said if the mainstream media had mobilised in favour of Assange and revealed the irregularities, the conflicts of interest, there's no way he would still be there, because the case is...
None of these wars that he exposed would happen.
Exactly. They are complicit, man. And that is their role. That's what you understand now. They are mainly performing, and that's also why they hate him so much, because he exposed them. Yeah. He exposed their real role. So the judges today are a continuation of that trend. As I say, they weren't quite as dismissive, but they're smart people. That might be a PR strategy on their part. But as you mentioned, Dustin, I think that was a really important point. That I noticed exactly what you were saying as well. That the British judges, the Assange defence lawyers, seem to be appealing to the fact that they were going to get their asses handed to them at the ECHR, which I think they probably would, because the case is so thin. But I have to say, the story I did this week was about a UK citizen called Beba Ahmad who was extradited to the United States in 2012. He was actually extradited in a batch with Abu Hamza, and he was in prison with Abu Hamza, a prison called Long Lartin up north. And his description of the conditions that he said to me that one day in the US prisons is like 100 days in Belmarsh. He was like, it's totally different ball game. He was taken there after 5 years. The European Court took 5 years to look at his case and then okayed the extradition. He was taken and then put straight into solitary confinement. He said he went there and met with the medic, and he noticed the medic have a little wink with the person who was the prison guard, and he realised that they basically put him on suicide watch, even though he was perfectly fine. He said it was just like they were laughing about it, this kind of thing. And he was in solitary confinement for 2 years. He said the only conversations he had were out of the sort of like hole in the door with other people who were shouting into the atrium. And I said to him, "How do you survive that? How do you survive?"
This is really primitive and barbaric.
Yeah, and he said what they're going to do to Assange will be worse. And then he said that the only way he survived it was his religion, Islam. And he said a lot of people don't survive. He said I had many sleepless nights with people just screaming non-stop. And but the Rule 39 that he mentioned and is a possibility for Assange. Again, in this case, as we've outlined tonight, they can not abide. There's no precedent for them not abiding by a Rule 39 from the European Court, but
anything goes. Yeah,
anything goes in this, exactly, and they can get him out the jurisdiction. Like there was
it.
one case in 2014 where a Belgian terrorist was drugged and put on a plane without even telling his lawyers. And then the Rule 39 was issued when he was out of the jurisdiction, so they could totally do that. They could just, because he was explaining to me that what happens is if the ruling goes against Assange, then it's literally as every day as they go on the website of the European Court and just do a submission for a Rule 39, and then it can take a couple of days. So the British government can just get him out, and they take their orders from the CIA anyway. So they get a plane at RAF Mildenhall, which is where Beba Ahmed go, and just get him out of the country.
Yeah.
So we'll see.
I think there will be I'm not going to say a lot, but significant political backlash if they do that. But they would risk doing it anyway for the Americans. That's what I think. It's definitely a possibility. Yeah.
All right. Well, I think we are about ready to wrap up this second episode. Again, this is a part of a 3-part series in which we sit down with a series of guests to discuss the latest developments in this case. And so we conclude this evening. This is the Truth Defense live stream. I want to thank our panelists, Mohammed Almazi, Matt Kennard, Richard Medhurst, Dustin Hoffman, and Richard Werner. I'm your host, Taylor Hudak. It's been a great pleasure hosting this evening. Please be sure to catch us for the final episode tomorrow, same time at 8 p.m. Have a wonderful evening and take care.
Thank you.